Is good to go. All right, so welcome back to our webinar on bulletproofing ideas and protecting inventions. So briefly, Mr. Haziq here is a patent executive at CAS International. Am I right?
Yeah.
Yeah. So CAS International, they provide advisory and consultation services in all intellectual property issues, including filing, prosecution, and maintenance of IP rights. For example, patents, trademarks, industrial designs, copyrights, and etc. And they also help to draft IP-related agreements. So we have an expert here on how to protect your ideas and inventions. So I'll pass the floor over to you, Mr. Haziq.
Hi guys, how's everyone? Hope everyone's doing well. I'm Haziq from CAS, and hope everyone's having enough coffee and having a good morning. So today I'll be speaking about an interesting idea or an interesting topic on how to bulletproof or to secure your ideas. So I'll just go to the slides. Give me a second. All right. Uh, so bulletproofing your ideas or how to secure your ideas. First of all, what are ideas? Ideas, thoughts, conception, literally what runs in your head, everything you think about. Ideas. Ideas are what runs the world. Look around you, you see things. Everything basically came from an idea. A chair, a table, a light bulb. If Thomas Edison were not to have put his mind and effort to improve, illumination by using something other than a candle, we wouldn't have such products today. Everything came from ideas from interesting people who thought about this kind of concepts. Without ideas, we wouldn't have nice things today like bubble tea, boba ice cream, and even today's bubble pizza, which is very weird, but it's why not, right? So if you can see in the slide, typically someone would want to get a 2 ringgit coffee at the mama, and it's something that's very practical, it's very cheap. And out of nowhere, Starbucks came in introducing their coffee at a higher price on an average of 12 or 14 ringgits. And the interesting part is they do it very well and people actually want their product. You see, Starbucks not only brought in coffee, they brought a new concept with their coffee, which is coffee to go or a takeaway coffee, giving consumers the ability to enjoy their coffee in an ergonomic container and an easy to sip kind of design. So it's not just only coffee; it's a coffee with a new idea, something that eases people's consumption, and evidently ideas help create a unique selling point for products. Like I mentioned earlier, today we have bubble tea, cakes, and people are putting bubbles on the cake. Ice cream with bubbles, and even pizza with bubbles. Like literally, people are just putting bubbles everywhere and selling their products. Similarly, like cheese or deep frying everything. This is an example of how an idea can make a business unique. Ideas make people want to buy something. It motivates people to buy a product, and they actually don't mind spending more money on a similar product in a different kind of concept. For example, like I mentioned earlier, companies like Starbucks or Coffee Bean. So they look at a gap which other companies do not attend to. Bringing coffee on the go, bringing coffee, takeaway coffee, having it, on the run, making it easier for people to consume it. And people don't actually mind spending a higher premium to buy a product if you, assist them in something which other companies can't attend to. So ideas essentially, they serve as a differentiating factor between a product and another product. So if one has an idea, why should someone protect it? Can anyone guess? Well, personally, I feel that if you have an idea which you put your mind and effort, blood and sweat into, why should others deserve to take credit for it? If you've developed an idea over the years, through brainstorming and just getting experiences, listening to people and stuff, Why would you let someone else use your idea? Because ideas are essentially assets, and the owner of the idea deserves the right of exploiting the idea. So ideas are assets. Nowadays, big companies are diversifying their streams of income to intangible assets like ideas, or they protect it and through intellectual property, and it brings great profit to the company. If you look at big companies like Google, if you look at big companies like Apple, people know them because they have a big reputation in the market, and it makes you a good market player, and it gives you a good reputation by not only having ideas but having protection of your ideas. Ideas help flourish a business. It keeps the company creative. It increases the productivity of the activities. For example, one of famous ideas that were brought into a company and the workflow was a Japanese concept called Kaizen. Kaizen is a concept developed to continuously improve business activities, keeping everything efficient. Which is why if you go to Japan and you see the businesses run in Japan, you see that everything is very, very efficient. From how some restaurants work. Some restaurants there, they only have one person who's in charge of serving you, taking your order, and cleaning up. Everything it just involves one person. Obviously, this is relating to the culture of the people as well. I don't deny. And of course, reasons you should protect your idea is to have monopoly. Having monopoly is having the ability to solely exploit the rights of an idea, and it keeps you on the upper hand, making you distinctive, and people look forward to do business with you through means which I'll speak about later. Here, I'll speak about different types of IP protection. Before I discuss, let's establish a fact. Ideas can't be protected until they are reduced into a substance. You can't just protect an idea. It has to, for example, be in the form of a prototype, a literature, or an artistic work. As you can see in the figure, there are around 8 types of intellectual property protection. Top left, you can see designs, and designs protect the aesthetic value of a product, the shape, the container, how does it look. Patents protect the technological aspect of a product, the science behind it, how it functions, what advantage it gives, what problems it solves. Trademark protect the distinctive mark, the name of the product. Copyright protects the literature or the artistic work. Trade secret, a good example would be Coca-Cola keeping their ingredients confidential and not telling anyone about it. You have confidential information, which is like companies who don't keep their client list or standard operating procedure confidential. You have plant varieties, which is exclusive rights given to breeders for their new plant varieties. And you have layout of integrated circuits, basically protecting the arrangements of chips on semiconductor devices. Next, we see that an illustration of how different types of IP protection protect different aspects of the product. You have industrial design to protect the design, shape, or shell of the cell phone. Trademark to protect the logo or the brand. Patents is focusing on the technological aspect of the product. So it could be the software, it could be something relating to the mechanical features. And you have copyrights to protect the algorithm or coding behind the software. So once you choose to protect your product, you may enjoy a lot of benefits. In this diagram, you can see how different types of benefits you can enjoy. Amongst the famous ones is premium pricing. Premium pricing is basically, once you have the monopoly of that product, you can set a higher price. And, other people don't have choice but to buy it if they, want your product. Because there's no other brands, You have licensing. A good example would be Microsoft. They license their software to run in different operating systems. So the companies would have, other companies would have to pay Microsoft a certain amount of fees so that their programs can run on their operating software. Franchising, basically people looking how to open their own branch of your product, like McDonald's opening a branch here, a branch there. That's franchising. You have cross licensing. A good example would be a HDMI company licensing other companies the right to use their product. Therefore, you can see that other products are also using HDMI port, HDMI insert, and basically the technology itself. And normally, cross licensing happens when one company licenses out their technology to more than one companies. Assignment, for example, Google buying Waze for 966 million US dollars to get the rights to use the Waze or to own Waze. And evidently we can see how the benefits can be derived only once you protect your products through intellectual property. Hope everyone is still listening. So let's take a look at an interesting case study, Mary Brown. Mary Brown is a fast food joint present in a lot of places in Malaysia. And if you do not know, it's actually a Malaysian-based company. It started off in Johor Bahru 1983 by a couple named Dato Lawrence and Datin Nancy. But prior to Mary Brown being in Malaysia, actually American fast food joints were already present. So what made Mary Brown something different? Well, they brought their own idea, and the idea is basically to bring a Malaysian food taste or Malaysian fusion in the fast food market. So not only they came with burgers or fried chicken, they came with nasi lemak with their own fried chicken, which is called nasi Mary Brown, and I can see that in its trademark. They have their own chicken porridge, nasi ayam, mee curry, seafood porridge, as you can see in the slide, which is something new. It's something that people didn't really think of, because when you want to enter the market, you don't want to enter with the same thing, which is what everyone is doing. That would make you special. And by not only coming in the market but protecting their product, we can see that Mary Brown, the developments of that Mary Brown had established. Currently, they are operating in 20 countries, mostly in the Asian continent. But regardless, that's a lot of countries. And now the franchise fees is 120,000. Initial capital is estimated at around 600,000 to 800,000, and you would have to pay the royalty of 4%. And this information is actually from the website ifranchisemalaysia.com, just in case if anyone wants to refer to. So a simple Malaysian taste fused with American fast food, utilizing intellectual property such as trademark and franchising, it brings them success. Evidently, like I said, it's operating in 20 countries, and the franchise fees is very high. The initial capital is at 500,000 to 800,000 almost, and you're paying a royalty of 4%. This shows how the benefit of a franchise is that it helps you really go in the market strong. Another benefit of franchise is that if you realize franchisees, they tend to have the same quality and a consistent look or taste and taste with each other. That's why if you go to a McDonald's in Tamantun or you go to a McDonald's in Montclair, you see that it looks the same and the food practically tastes the same. This is amongst the benefits of going for a franchise. Another case study, Apple products. The Apple company is a giant in the technological field. They brand their products very, very well, if you have not already noticed. And a lot of their products are very distinctive compared to other products. For example, the iPod. When the iPod came out, people, back then referred to music players as, MP3 and all this. But when iPod came out, people used to, they forgot about the word MP3 and they started labeling every single music player as iPod, showing you how great influence Apple products bring to the people. And what's interesting is that there are certain aspects of the product which people can which clearly distinguishes Apple products from other products. One of the famous example is the circular dial, which everyone knows only Apple has it. And as you can see in the slide, the design of the iPod itself is not similar to other products. And they registered the product, they registered the design of the product as shown. And this gives them a uniqueness in the market, making everything, making them different from others. And another example is the tablet devices from Apple. If you can remember well, when they came out, they had this home button, started off with the iPod Touch and now to the iPads. And it's something that people know Apple for. So in this example, it shows how a company can use design or trademark to increase the product value. Another great example in recent years is the Joule. Joule is basically a pod vape that was started in America. It was amongst the first pod vape products in the market, and it had a very distinctive design, and the company actually utilized intellectual property to keep them strong in the market. By doing this, they branded their product so well that the word Joule, which is the company name, became a verb. Like kids in America or other places in the world, they would start using the word Joule, like I'm juuling instead of I'm vaping or smoking. That's how how much influence a company can bring to the people, similar to Apple. And you can see in the next slide is that Joule had a lot of intellectual property assets. They practically patented many, as you can see, many technological products. They have trademarks, and obviously they have their website under copyright protection. By doing this, it makes them a big market player, and people wouldn't dare to copy or infringe their products. Here's an example of a front page of a patent document showing a brief description of a product. So you have the patent number at the top, and you have the simple diagram of the product at the bottom. You have the abstract to speak about what the product is about or what the patent is regarding. So in the same document, you have the claim section, which shows you everything the company wishes to get exclusive rights for. So you can see that in this claim, they're claiming something regarding a cartridge for vaporization device, and the cartridge comprising all that. And if there's any other company who wants to use the content or what's mentioned in the content, they would actually have to approach this company to get a license from them. So like I mentioned earlier, this gives you a monopoly in whatever you're claiming for, which makes you a strong person in the market. So we see that, businesses can be secured by protecting the technological aspect of a product, patenting in this case. Next, we see, a family recipe, it's something you can develop into a very profitable business, a restaurant maybe. For protecting a recipe, you can go for a trade secret or a patent if the exact ingredients are disclosed. However, one should know that copyright is a way of protecting the content or the literature of the art, and not the action through the content of your literature. For example, let's say you have a copyright for your book, the recipes for your food, and someone uses your food to serve food in their restaurant. Would that person be infringing your copyright, or would that person, can you actually take legal action against them? Can anyone guess? So basically, if someone uses your recipe in their restaurant, you can't take any legal action. Like I mentioned earlier, copyright only gives you protection on the book or on the literature or the art, and not the action of someone using the content of your book or content of your book. Hence, many companies prefer protecting their recipes under trade secret. For example, Coca-Cola keeping their contents of their drinks, not disclosed. KFC, no one knows what exact recipes or herbs, spices they're using. Now, let's say you have a plan for your idea. What should you do? What do you guys think someone should do if he has an idea? Well, I'm not sure what you guys are writing in the comment section because I don't really see it now, but uh, you should pitch it. What I mean by pitching it is, if you see TV shows like Shark Tank or Dragon's Den, you probably notice it's about entrepreneurs pitching their ideas to potential investors. Potential investors, and if the investors like the idea, they'll help kickstart the business in exchange for a certain share or royalty. But how does one pitch an idea safely? Because if you're pitching an idea, you're basically disclosing your product, or what how your product works and whatnot, and that is basically the opposite of protecting your idea. So how does one pitch it? Firstly, you could protect your idea through intellectual property prior to the pitch. Otherwise, you could go for a non-disclosure agreement, which is basically keeping everything confidential. But one should note that major corporations may not consider signing it, as they have a bigger bargaining power. So small startups, they might go to big companies to tell them about the idea, and they might not agree to sign it because, like I said, they're the one who has the money, and they're the one who have the power. So why should they agree to sign a non-disclosure agreement with you? So when is the perfect time to protect your product? Anyone? Anyone knows? Is it when you have an idea, or is it when you have reduced your idea into a substance? Well, to keep it simple, it's just two things basically. The best time to protect your idea or to protect your product is after reducing it to substance and before you put it in the market. Because if you put your product in the market before protecting it, then you don't have protection. Because typically, an idea can only or is preferred to be protected when it's new. Because if it's not new, how is it going to be protected? You might violate the requirements for protecting your product. So I hope I've addressed everyone's concerns and give you guys some information on how to protect your products or ideas. And we at CAS advise to all the entrepreneurs or future entrepreneurs out there. First of all, do not disclose your ideas openly without taking any safety precautions. Always have a plan on how to enter the market. Don't just enter the market, enter it strong by protecting your ideas or product. And it's best to always consult a professional to assist you on how to enter the market safely prior to entering the market. And yeah, so if anyone has a question, I'll be happy to answer. Preferably questions that relate to today's topic. Otherwise, I can write you an email regarding whatever you're asking for.
Hi, Haziq. Thanks for the sharing.
Yeah,
So far there's only one question by SP. He's asking whether there is any IP protection over Kaizen.
over Kaizen.
Yeah.
Well, Kaizen is a concept for business,
Mm-hmm.
and we know that businesses or businesses some things in can be protected in Malaysia. For example, something that's not new, of course, and businesses strategies, which is basically Kaizen,
I
and
see.
therefore businesses concept can be protected.
I
Maybe
see.
through other ways, maybe putting it in a book and protecting that book, but Kaizen itself can't be protected.
Oh, okay. Okay.
Regarding the Kaizen I mentioned earlier, it's a business method, and only America and Japan allows it, not in Malaysia. Just to
Oh,
add to that.
all right. So thank you very much. Thank you to Haziq. So we'll end our webinar here today. But okay, there's one question from Mega. What should I do if I don't have time to file for IP for my idea?
What should I do if I don't have time to file for IP?
I guess he has an idea, but doesn't have the time to file for protection.
Oh, what should you do? Question is, what can you do?
Don't market it first until you find the time, right?
Yeah. Sorry. What should you do? Yeah. So basically, as I was saying, first of all, if you have an idea, you shouldn't disclose it to anyone. You should keep it confidential um, until you have it protected. Then you can safely disclose. Otherwise, if it's not protected and you still want to disclose, like I mentioned earlier in the presentation, you should go for something safe, like a safety precaution, like a non-disclosure agreement or NDA. So hopefully everyone got that.
Actually, Haziq, I have a question.
Yeah,
Let's say copyright, right? Once you write a book, that copyright belongs to you even if you don't file any sort of registration or anything, right?
correct.
Oh, so what if I remember there's some sort of a notification to the government department to the my IPO. Is there something like that for copyright?
There's a notification on.
Copyright.
Yeah.
Yeah.
Sorry.
So is it recommended that I do that, or would it be safe once I publish the book? Like it doesn't matter whether I submit the notification on that copyright itself.
Well, first of all, copyright is a automatic process. Once you
Mm-hmm.
have your published literature or artwork, it's something that's automatic. But it's always best to get it registered with the IP office.
I see. But what is the added advantage to have it registered with the IP office?
Well, the difference between getting a copyright application and without, it's a long topic. So what I can do is maybe I'll just drop you an email or something regarding
Oh,
this
sure,
because
sure, sure. No problem.
yeah,
All right.
because
There's another question
yeah,
by Alice.
what can I do if
What
someone
can
uses my idea before I protect or file my idea, assuming a person uses the permission? Uh, Generally, in Malaysia, we follow a first to file kind of basis, which means that whoever files it first gets the right of that idea. And what a person can do, it depends. How do you have proof that person took your idea without your permission? Is there any kind of evidence you can show to the court? And it depends, case to case. It's quite hard to say, whether what a person can do. But generally, he might get away with it if there's no evidence, if there's no proof. So, which is why I mentioned in today's topic, it's always important to protect your idea before going to the market. Because once people copy it, then there's a lot of problems.
So what can I do? So that question is what can I do if the person uses the idea before I file it? So let's say, okay, the person used my idea already, then I file to protect it. Can I get action against that person since there is like a evidence of me filing to protect the idea?
Well, let's say it's a patent application.
Hmm.
It's a patent idea. Typically, you can only take action or legal action only once the application is granted. Otherwise, there are other things you can do. For example, one of the famous things that a lot of companies employ is sending warning letters,
Okay.
basically telling them, look, I have this idea and it's already in the application process, so it's on the way. And let's say it's granted, right? You can
Hmm.
take legal action within 5 years prior to that grant. So meaning if that person is making profit from your business, from his business with your idea, or if you're losing money, it's something that the court can make them pay you back for.
Oh, I see. Then that's great then. All right. There's two more questions. One by No Hafiza. What to do if we have disclosed our invention or idea? Can we still protect it?
In Malaysia, we have something like a discount. We call it a 12-month grace period, which means that once you disclose your idea or product, you can still file it within 12 months without killing the novelty of the idea. Otherwise, if you file it after 12 months, the examiner might say that, look, your idea has already been disclosed more than 12 months, and therefore, it's not novel anymore.
Okay, next question by Vijay. How to protect a technology for businesses in Industry 4.0?
Well, it's just same as protecting any technology, um, regardless of what kind of industry, 4.3.0, 5.0, it's all the same thing. It's just protecting your technology per se. How do you protect it? Well, with IP, like I mentioned, different types of IP. You want to employ copyright, you want to do patents, you want to trademark, go for it, go for all of it. Why not? And also just want to say something, right? Uh, he mentioned that it's businesses in industry 4.0. I just want to mention that business method is not something which you can protect with intellectual property in Malaysia. Sorry, business method can be protected under patents in Malaysia. Just wanted to bring that up.
Yeah, something like Kaizen, right?
Exactly, something like Kaizen, or even method of treatment also cannot be protected in Malaysia, but other countries can you can go for it. Yeah, business strategies like multi-level marketing or concepts, something you can protect under patents.
If there are no more questions, perhaps we'll end the webinar now.
Very
So
nice.
thank you very much, Mr. Azik.
Thank you, Rachel. I hope I've answered most of the questions and your concerns as well.
Yep, okay. Thank you very much. Yes, it did. I'll
Thank you,
email you
Rachel.
more if I have any more questions.
Please do. You can email
Okay.
us at cast@cast.asia, and we'll answer
Oh,
your
right.
questions as soon as possible.
Okay, so that's it for today. Thank you very much. I'll see you
Thank
next
you
time.
so much.
All
See you, Rachel. Bye.
right, bye.